Oh, no. All right. Hi, everybody. Welcome to Ivy Law Office. We're here with Attorney Jumoke. Say hi, Jumoke.
Hello, everyone. You're welcome.
Yes, yes. We're happy to see you. Those of you who can see us, we're happy to be with you. Today, we are going to talk about estate planning in Maryland. Ivy Law Office handles estate planning and trust for clients. We're in Maryland, Greenbelt, Maryland. So if you need estate plan, you know where to go. We're going to give a little Q&As about it. And then afterwards, we'll let you know, we'll give our information on how to contact us, which will also be included in the description for the video. So without further ado, I'm Force Ajikum. I'm an attorney here at Ivy Law Office, but I handle strictly immigration. And Attorney Jumoke is a licensed Maryland attorney, so she handles immigration and estate planning. She's one of the best estate planning attorneys in the state. I might be biased, but I've seen her work, so I'm saying that. Okay, so you guys are in for a treat. All right, estate planning, Attorney Jumoke. What is it? What is estate planning? We hear about it all the time. Tell us what it is for those of us who don't know what it is.
All right, thank you very much. A lot of people hear estate planning, and they don't really know what it means. Some people, when they hear about estate, they think is real estate, buying a house or owning a home. However, estate planning is not real estate. Estate planning, first of all, what is an estate? Okay, that's what we want to know. What's an estate? An estate means your property, your assets. So that could include your real property, your personal property, your bank account, your life insurance, your stocks and bonds, and things like that. So everybody has an estate, whether it's small or not, because you have a bank account, or maybe you have a life insurance, or maybe you have a home, a real property, or any other personal property like your jewelry, your clothes. Like I'm wearing a jewelry now, that's part of my estate, you know. So that's it. And when you talk about estate planning, it means how you plan your estate in such a way that it's beneficial for you while you're alive and after you're gone. A lot of people think estate planning is just for after you're gone, after death. But no, it's both planning for life and afterwards. So how do you plan for life? It includes things like financial planning, tax planning, and distributions. Basically, what a lot of people know about this, the plan is planning on how to distribute your assets when you're no longer alive. That's part of it. And it also includes things like planning on who will take care of your children when you're no longer there. It also includes planning for who will take care of your children on the short term in case of emergencies. It also includes things like planning on who will make healthcare decisions for you when you're not able to. It also includes something like making decisions on whether you want to be on life support or not, or whether you want to be buried or cremated. But more importantly, your financial plan on while you are alive, who will make decisions for you if you're not able to make decisions by yourself. Healthcare decisions while you're alive, who will make healthcare decisions for you, how you want to be taken care of in the event that you cannot make healthcare decisions for yourself. And then after death planning, which includes how to distribute your assets when you're no longer here, who you're giving what to, who you're nominating to administer your assets, and how to distribute your assets. So all those things are part of estate planning.
Okay, that answers my next question of what is included in estate planning. Thank you very much. Now, who do you say needs estate plan? Who needs it? I'm sure you can say everybody, but especially who would you say really needs it the most at this point?
So the general answer will be anybody that has an asset needs an estate plan. Okay. So it now depends on, do you have an asset that you want to give to someone? Yes, you need an estate plan. But also bear in mind that we spoke about you making healthcare decisions and making financial planning decisions. So that's not about assets. That's about taking care of you. Do you understand? So if you're in a situation where you want to plan for incapacity, who will go to the bank for me? Who will sign legal documents for me? Who will make decisions when I'm not able to? Then everybody, every adult needs an estate plan. In that minimum, having a financial power of attorney and a healthcare directive. But if you have a modest asset, like a home or personal properties, then yes, you need an estate plan. If you have a blended family, I believe, yes, you need an estate plan. So what I say is this: if you have anything to distribute to anybody, or if you have assets probably modest 50,000 and above, that's regular estate in Maryland, yes, you need an estate plan.
Very good. Now, what questions should one ask in order to help the attorney create a successful estate plan for them?
So right now that we know who needs an estate plan, one of the things that people, you're confused, but you have an attorney to be able to explain things to you. So you want to set up a session with the attorney. The attorney actually will be moderating. A real estate planning attorney will be asking you questions and you will be answering, because the attorney knows what to ask. But if you want to ask questions of the attorney, estate planning attorney, then you need to know, and who will be my beneficiaries? Who is the person that I would like to make decisions for me? Like, who will be my power of attorney, or who will be my personal representative? What is your objective with estate plan? Do I want to avoid court and probate or not? Those are part of the discussions you want to have. Also, if you have like a magnificent amount of assets, you want to talk about asset protection. If you have a blended family, you want to speak about how your out of wedlock child will get something. You want to talk about, if you desire to disinherit someone, you want to speak about that and ask about that. You also want to speak about who will be responsible for your personal care, who will be responsible to make healthcare decisions and stuffs like that. Those are the questions that you want to ask your planning attorney, or the estate planning attorney should be asking you.
You had more to add?
Oh, yeah. Who will be your beneficiaries also? That's important.
That's very important. You got to know who to give it all to.
Yeah.
And okay, that's great. You touched a little bit on it, but what exactly is a will? Most people think they know what it is, but in Maryland, what is a will and what is a legal version of a will? How do you do a will legally? And what is it?
All right. So a will is a legal document or a legal instrument that you will use to pass your asset or distribute your asset when you're no longer alive. That's in the event of death. So a will gives you two things. First of all, you choose in a will who will administer your estate, who will be your personal representative. You also state who your beneficiaries are in the will, and then how you want your assets to be distributed. All those are part of the function, the terms, the major terms in a will. There are also other things there, like the powers of your personal representatives and what you want them to do. So a will is a legal document that specifies how your assets are distributed in the event of death. A will also is used to nominate long-term guardians who will take care of your children in the event of death. And a will also says who will administer your estate. A will becomes effective upon death.
Good. So that's fantastic. Upon death. So once the will becomes relevant, nobody can change it, right?
Exactly. It becomes like irrevocable, and your
Yes,
wishes will be honored at that point.
that's right. Okay, fantastic. Now, does a will have to be written to be enforceable?
It's better written.
Mm.
Yeah. Because if you say it,
Mm-hmm.
yes, the judge may take a look at it.
Mm-hmm.
Some people write what we call holographic wills, like
Mm-hmm.
handwritten will. Um, that could be a cause of conflict, but yes, it's a will. But yes, it's better if it's legally documented, written
Okay.
down.
And does it have to be notarized for it to be legal at all?
Okay, so each state has the requirement for a will to be effective, okay, to be properly executed. So, and these requirements may differ from state to state. However, in Maryland, for a will to be categorized as executed properly, you need to have the testator, that's the owner of the will, sign in front of two witnesses, and also probably notarized, but the two witnesses section is the most important part of it. And it has to be in front of them, and the witnesses still needs to sign at the same time.
Oh, okay. Fantastic.
So the notary part of it makes it more like authenticated. It's for authenticity.
Oh, okay. That makes it easier if it comes to a court dispute or anything like that.
Exactly.
Hmm. Thank you. Okay, so what is probate and what is the process of doing probate? What is that?
Oh, yeah. When you hear probate is the process of administering a will, usually through the court system. And the court that administers probate cases is called the probate court. So when someone dies, one of the people, if you die with or without a will, for example, if you die with a will, then the person that is listed as your personal representative or executor goes to the probate court and opens an estate on your behalf. And then with the court's approval, the process and everything, does an accounting on what you have, then goes through what the terms of the will are to administer what you've written down. So let's say you give your house to your son, then the house title will go to your son. If you die without a will, that means you die intestate. And there is the laws of each state on distribution if you die intestate. And you have to go through the court system as well, called probate court. So yeah, probate is the process of administering your estate after you die.
Mm-hmm. Now, you said without a will. Can you explain that some more? What happens without a will? How does somebody get their estate probated? Is it easy or is it more difficult?
It becomes more complicated if you die without a will. And this is why it creates, number one, a lot of conflicts. Because your interested persons, probably your children, your brother, your sister, your siblings, all of them are interested persons. First of all, there may be conflict over who will be a personal representative among them. Then your spouse too is among your interested persons, because you do not nominate anyone as your executor or personal representative. Then any one of them could say, hey, I want to be a personal representative. And if there are two people that raise up their hands and says, yes, I want to be the not personal representative because they think one person is financially irresponsible, there's going to be a conflict. That's the start of, the results of not planning. Then, the judge will have to be the ones making a lot of decisions for you before your assets can pass, according to the state law of intestacy.
Oh, fantastic. And what is there a particular order, like in Maryland? What's the intestacy order?
So if you have a spouse and you have minor children, your spouse probably gets, I think, 50% of your estate, and your minor children gets the other percentage. If you have adult children, I believe the spouse gets 40% and the adult children gets the rest. If you die without a spouse and you have children, your children share the estate. If you don't have a family, probably they look at parents, brothers, and who are your heirs, basically. So it goes on and on and on, and that's the intestacy law.
Okay, fantastic. Can one change or revoke a will after it has been created?
Yes. If you create a will, then you can change it at some point. Let's say, generally, people do change. Your beneficiaries can change. Let's say you have 3 children and one passes away, then there are 2 left. Or maybe your assets change. Maybe you had 5 properties when you created the will, but you've sold 2, remaining 3, and you gave the other 2 to some people. The assets change. Your beneficiaries can change, your assets can change, the law can change. And because of all this, yes, you can recreate a will. It's called a codicil. If you make changes to your will, like an amendment to the will, is called a codicil. So you can do that, or you can revoke a will and create another will. There shouldn't be 2 wills at a time for one person. You should just have 1 will per time. So if you want to create a new will, then you have to revoke the old one.
Fantastic. And what is, I guess you might have answered it, but it's also a trust partner. What is a revocable living trust? I guess you might want to talk about trust and then tell us what a revocable living trust is.
All right. A trust is an agreement. And there are different types of trust, but basically is an agreement between you, who is this trustor, the creator or the settlor, and you, who is the trustee a lot of times, and also a beneficiary. That's a revocable living trust. You're the beneficiary, you're the trustor, you're the trustee. A revocable living trust, it's like you putting your assets into the trust, so that while you're alive, you're the owner of the trust, you're the beneficiary, you're the trustor. You're the owner, you're the beneficiary, you are the manager, called the trustee, and you manage your trust, but it leaves your name to the name of your living trust. Basically, the purpose of a revocable living trust most of the time is an alternative to a will, to avoid you having to go through the probate court. And the reason is that anything in your personal name at death goes through the probate court. But when your asset is in the name of your trust, living trust, revocable living trust, then it doesn't have to go through probate. It's administered in the privacy of the attorney's office. There are a lot of advantages to that. So it's called revocable because you can create it, you can change it, you can revoke it and set up another one. Because a lot of things go on while we are still alive. Okay. And there's advantage in creating a revocable living trust as an alternative to a simple will, which we'll talk about later. Did I answer your question? Did you say something about irrevocable as well? Or just
Yeah, you can, yeah. What is also irrevocable, since we're on the same topic?
So when after death, a revocable trust becomes irrevocable. Okay, and that's when it becomes like a will, and all your wishes are administered at that point without the court's involvement. There are also different types of irrevocable, there are other types of trust called irrevocable trust. But an irrevocable trust is what it means. You cannot change it. You cannot revoke it. Most of the time, you're not the beneficiary. So you own the property, but you're not the beneficiary. And it's usually used for some form of assets protection.
Excellent. Now, one quick question about wills. How about when you die, we talk about estates and beneficiaries. How about liabilities and debts? What happened when one's die with the estate plan in regards to debt and liabilities?
Can you say the question again?
What happens with respect to somebody's death and liabilities, creditors? What happens?
Okay. So when you die, or when someone dies, part of what will be administered is how your credits, basically, or your debt. And you have to pay your debtors if you have assets to pay them off. Usually there's going to be a newspaper publication that says, hey, Mr. X is dead. If you owe, if Mr. X owes you, file a claim in court. And then you see banks and creditors, credit card companies and things like that filing claims, hospitals and places like that. Yes, if you owe and you die, you have to pay. If you don't have an asset to pay, then your estate probably still owes because it's a claim on your estate. And whenever you get anything, as it drops, the creditors are paid.
You gotta pay the creditors. So whether you're alive or dead, they're gonna be paid.
Exactly.
So I guess you want to be safe.
It's not a debt for your personal representative. It's not a personal representative's personal debt. And a lot of people think that if they become a personal representative, then maybe they're allowed to carry the liability of the deceased person. But no, the personal representative's account is different from the deceased account. So it's whatever is your money that is used to pay your debt. The personal representative is not personally liable for that.
Awesome, awesome. Well, we are at the end of our question and answer. Is there anything you want to add before we close on estate planning in general and how people can come see you at Ivy Law Office? Let us know.
All right. I hope you've all learned a lot today, at least something about estate planning and why you need to plan. If you don't know why, if you don't plan, the state has a plan for you. If you don't plan, a judge will be choosing people to act on your behalf who may not be the same people you would have chosen. If you don't plan, you're inviting conflict into your family. 1 minute. Sorry. If you don't plan, you're inviting conflict into your family because then people will rise up to say, yeah, I want to do this, yeah, I want to do that. And some people will think some other people are incompetent. And at that expense, there's a lot of family conflict created because of lack of planning. If you don't plan, you are subject to paying a lot of probate costs and expense and taxes that you could have saved and used to preserve your family's wealth. If you don't plan, then the judge will have to choose who will be the guardian for your children, particularly if they're minor. There are a whole lot of reasons why it's important to put a plan in place. Even if you want to start with planning for while you're alive, having a power of attorney in place and having a healthcare directive in place. That's very important. If you don't plan and you have a spouse and you have an adult child, there could be a conflict about always making decisions between the two of them. So I can go on and tell you why it's important to plan, but those are some of them. So if you don't have one in place, don't procrastinate. A lot of people push it up, push it to another day and another day. It's not really important to them, but I tell you, it's very important. It's like having an insurance on your car. You don't know when you'll have an accident. So we are here as attorneys, estate planning attorneys. We know what we do and will help you to preserve your family wealth. And we do value-based services. We help you to look at everything you have, who you want it to go to, and make the best decisions out of it for you so that your wishes and your desires and your intentions are put in place in proper form so that they will work when it's needed. So I invite you to have a talk with an estate planning attorney. You can call us. We start with you having a family wealth planning session in our office where you will be speaking one-to-one with me, and I'll be learning about you, your family, your assets, and what will happen to you in the event of death or incapacity, and what loopholes you have, and how we can close that gap through creating a proper estate plan. So that's what we do. Then we go ahead from there to create a plan for you. You can call our office, Ivy Law Office. We're in Greenbelt, Maryland. We serve clients all over Maryland, and you can meet with us via Zoom or in office. So our phone number is 301-276-0887. You'll see it's on the chart down. And also you can visit our website to learn more about our office, www.ivylawoffice.com. And if you have any questions, jump on to our Q&A on Wednesdays, and we'd love to answer your questions. And also you can listen to our estate planning webinar. We have that online, and just listen to it and you learn a whole lot. Then you can contact us afterwards. So that's it.
All right. Thank you very much, Jumoke. I hope you guys learned a lot. And if you have questions, please contact Jumoke at the office, and she'll be happy to sit down and talk about your estate planning with you so you can take care of your family when you are not able to and you're gone. All right. So thank you again, Jumoke, and I'll see you around the corner in a little bit.
All right. Bye.